Hello everyone, welcome to Analog IAS. Today we are going to discuss about ordinance making power of President and Governor. First let us discuss the common points regarding ordinance making power of President and Governor. President or Governor promulgates ordinances during the recess of Parliament. That is, when both the houses or either of the houses of Parliament or state legislature is not in session. It has the nature of a temporary law. An ordinance can also be issued when only one house is in session. That is, because a law can be passed by both the houses and not by one house alone. In Cooper case 1970, the Supreme Court held that the President's satisfaction can be questioned in the court on the ground of malafide. Later, 38th Constitutional Amendment Act 1975 made the President's satisfaction final and conclusive and beyond judicial review. But finally, this provision was deleted by 44th Constitutional Amendment Act 1978. Thus, the President's satisfaction is justiciable on the ground of malafide. The maximum life of an ordinance can be 6 months and 6 weeks, because the maximum period between any two sessions cannot be more than 6 months, and the Houses of Parliament has 6 weeks to pass the ordinance when it reassembles. So the maximum life of an ordinance is 6 months and 6 weeks. Also note that the power of ordinance making is not a discretionary power. President can promulgate or withdraw an ordinance only on the advice of Council of Ministers headed by Prime Minister. And also an important point is ordinances cannot be issued to amend Constitution. The ordinance making power of President and Governor is coextensive with the legislative power of Parliament and state legislature respectively. This means that they can issue ordinances only on those subjects on which a Parliament or state legislature can make laws. Also, President or Governor can withdraw an ordinance at any time. Next, the ordinance ceased to operate even earlier than 6 weeks if both the houses pass resolution disapproving it. Next, Article 123 deals with power of President to promulgate ordinances, and Article 213 deals with power of Governor to promulgate ordinances. Now let us discuss the instances where Governor cannot make an ordinance without the instruction from President. First, when a bill contains provisions which would require the previous sanction of President for introduction into the state legislature. Next, when an act of state legislature containing the same provisions would have been invalid without receiving the President's assent. Now let us discuss a question based on this. Consider the following statements regarding ordinance making power of President of India. Statement number 1. Satisfaction of President to issue an ordinance is final and cannot be challenged in the court. This statement is false. According to 44th Amendment 1978, the President's satisfaction is not final and it can be justiciable. Statement number 2. The maximum life period of an ordinance is 6 months. This is also false because the maximum life period is 6 months and 6 weeks. So the answer is D, neither. Thank you.